Hello, my name is Crystal Dahl, and I am the Online Communications Manager here at Meritas. I would like to welcome and thank each of you for joining us on today's webinar. For those of you that are new to Meritas, Meritas is an established global alliance of closely connected yet independent law firms that each offer a full range of high-quality, specialized legal services. We were built upon a rigorous system for monitoring and enhancing the quality of our member firms and have been connecting clients with carefully qualified business legal expertise in over 240 markets around the world since 1990. Meritas Capability webinars are regularly presented by Meritas members. Before we get started, I'd like to quickly go over a few housekeeping items. Meritas offers the ability to listen to our webinars through your computer speakers, but if at any time you have difficulty hearing the presentation, you may also call into the associated telephone line instead. All phone lines will be muted. If you experience any technical difficulties, please press *0 at any time to connect with a support technician. You may also use the chat feature found on the left-hand side of your screen to connect with me. Since you will be muted, you will have to ask any questions of Joel via that chat feature on the left-hand side. Joel plans to answer questions throughout the presentation. Lastly, in the next few days, I will distribute a copy of this presentation, a recording of the webinar, as well as the presenter's contact details. Feel free to share that with others who may find it of interest. Our presenter today comes from the Meritas member firm in Pittsburgh, Pennsylvania. Joel Pfeffer is a partner of Meyer, Unkovic & Scott. He is the chair of the Corporate and Business Law Group and a member of the International and Immigration Law Group. Mr. Pfeffer works primarily in the areas of immigration, nationality, and corporate law. With that, Joel, are you ready to get us started?
I am. Thank you, Crystal. And thank you to all those who are joining this morning for a discussion on how the Trump administration has changed U.S. immigration. Simply stated, the Trump administration has made it more difficult to immigrate to the United States, both in a temporary or what we call non-immigrant category or as a permanent resident. We've seen policy changes, procedural changes, and I think it's fair to say a basic deterioration in the relationship between the USCIS, the benefit agency that oversees this process, the U.S. Citizenship and Immigration Services, and both the public and the immigration bar. Now, how did all this happen? Beginning in January 2017, President Trump published 3 executive orders, and they're sort of listed here in inverse chronological order, but in the order in which I think they've had the most impact. The Buy American, Hire American executive order mandates the government agencies that deal with immigration to focus in on protecting the jobs of U.S. workers. Now, for those who are at all familiar with this process, there are 3 government departments that regulate this process: the Department of Labor, the Department of State, and the Department of Homeland Security. Traditionally, the Department of Labor's role has been to protect U.S. workers, and as we'll discuss in a few minutes, the process of obtaining a green card through the traditional method of what's called labor certification has always been through the Department of Labor, and their role has been to protect U.S. workers and ensure that whoever the employer is promoting to obtain permanent resident status in the United States will not adversely affect U.S. workers' employment. I don't think there's been much change in the Department of Labor process. I have not seen anything that is, I'm not going to talk much about it because I've not seen much with the Department of Labor. On the other hand, the Department of State, which governs the issuance of visas through its consular offices abroad, and the Department of Homeland Security, which governs both entry to the United States and benefits through the issuance of extensions of status and permanent resident or green card status in the United States. There have been some major policy changes and procedural changes that have in a significant way impacted the ability of foreign nationals to come to the United States. Enhanced vetting is another one of the executive orders where the Trump administration has said we are going to take a look at every single person through whatever means we can. And the travel ban, which was the first of the executive orders and actually created sheer chaos when it was first announced, because whoever thought of this didn't understand the ramifications and the issues that would arise from the travel ban. Now, these three executive orders have resulted in several things highlighted on this slide. The USCIS, the agency that governs extensions of stays in the United States and issuance of certain categories of employment-based temporary and permanent status in the United States, we've seen a higher level of challenges and denials on fact patterns that were previously approved. We were going to discuss significant delays in the process. The travel ban has required waivers for entry by nationalities subject to the ban, and frankly, even if someone subject to the ban has, for example, is abroad and is married to a U.S. citizen, there's going to be a need for a waiver, and I don't see any end to that process. Seems to be permanent that these countries, nationals of these countries, require waivers, and a proposal by the Trump administration for stricter public charge guidelines. And we'll explain that a little later. I believe that proposal, if passed, it's in the proposed regulation stage right now, I believe it's going to be a game changer for this process, at least with respect to certain certain level of immigrant in terms of financial ability. Just by way of an example, for those of you who might be listening from abroad, in order to get to the United States from either in an employment-based category or even as a visitor, unless you're from one of the countries that has what people now refer to as ESTA, or technically it's visa waiver, you need to go to a consular office to get a visa. A number of changes in the screening protocols have occurred. The Department of State has an extensive screening database called Consular Consolidated Database, which ties into several FBI, USCIS, Department of Homeland Security databases, and it is very, very comprehensive. But nevertheless, in connection with issuance of visas, the Trump administration introduced about a year ago something called Form DS-5535, which allows a consular officer to get awfully nosy about what people are doing. It's a supplemental question for visa applicants. It's used only in consular discretion and meant to be used only for foreign nationals who present a risk. But it can be used for anybody, and it requires applicants to disclose social media identifiers for the last 5 years, travel over the last 5 years, and in fact, the Customs and Border Protection has gone to collecting social media information and increased searches of electronic devices at ports of entry for both U.S. citizens and non-citizens. Those are just examples of what's happened in this world. So let's talk about some particular, I'll explain to you some particular non-immigrant and immigrant options for people to come to the United States and how the Trump administration initiatives have affected those. So the core program that most employment-based non-resident non-immigrants arrived in the United States is either the H1B program and the L1 program, and there have been some changes for this year's H1B program. There's some changes to the L1 program, and then there's permanent residents, people who come here permanently and seek to get green card status. And for those we're seeing interviews, enhanced vetting, and in certain cases mandatory interviews, which we had not seen before. So let's address first the non-immigrant H1B program. This is a program that requires, and I'll be very brief about the requirements, a professional position, a professional employee, meaning the position must be professional in that the position must require, as an entry-level requirement, a college degree, a baccalaureate degree. Now, an employer can't just say, well, I require a baccalaureate degree. The government has, the USCIS must be satisfied based on publications by the Department of Labor that the position itself that you've described is a professional position. The employee must be a professional in that that employee has a degree or the equivalent of a degree, as that's defined in the regulations, a combination of education and experience, and that degree or equivalent degree is related to the position. And the employer must be paying what's called the prevailing wage, which is based on statistics published by the Department of Labor. There is an annual limit or a cap of $65,000. Actually, it's $85,000 because there's 20,000 additional slots for U.S. master's graduates. Now, what changes have we seen in that? First of all, we've seen when you go to the Department of Labor statistics, they publish them by category at 4 levels, level 1 through level 4. And we've seen in the last 2 seasons, we've seen the USCIS challenge anybody who has claimed that they are paying, not anybody, but many cases where people are paying, where employers are paying a level 1 salary. Now, there's nothing in the law that says that you can't have an entry-level professional, but nevertheless, we've seen challenges on entry-level professionals, more and more challenges on entry-level professionals than we've seen before over the last 2 years. Now, for this year, for 2019, the USCIS announced a procedural change. The USCIS will select the 65,000 first, and then the 20,000 master's people, master's applicants. You don't need to understand what they're going to do and how it's different. What you just need to know is they are giving a higher priority to master's level candidates in this process. They are, they're they want the highest paid beneficiaries, and that's set forth in the executive order by American Hire American. We want to give the available slots to people who are the highest level or the highest paid. So there is by the way they're conduct this lottery, this who's going to get selected in these 85,000, they are, I guess, sort of rigging it the best they can to make it easier for the higher level professionals, people with master's degrees, actually U.S. master's degrees only, to get in. So it sort of skews the lottery in favor of U.S. gives a slightly higher percentage of chance of being selected to a U.S. master's graduate. Another thing they've done is they've announced that they are no longer going to give deference to prior approvals. That means, years and years and years ago, you could have assumed that if something was approved once, it's going to be approved again on the same facts. I would say probably around 20 years ago, the USCIS stopped. You could no longer live with that assurance. But in most cases, they would give deference to something that was approved previously. They have announced that they are not going to do that anymore. So, for example, here's a practical example. If you had somebody in a computer position, often the computer positions are challenged by the USCIS with a challenge that is a college degree really required for this position, or could somebody who has had 2 years of training or someone who's self-taught, can they actually do this? And it's very common that the USCIS will challenge that. We're seeing a higher level of challenge in positions that are described as computer positions, computer programmer positions, as opposed to a software engineer position and an individual with a software engineering or other engineering degree. We're seeing less of a challenge. Now, if you had a prior case, let's say the H1Bs are issued for 3 years and renewable for another 3. If you had an approval on a software profession, on a computer programmer case, don't be so sure that it's going to get approved again. Another thing they've done is they've imposed burdensome requirements on third-party companies. And for example, if you have a staffing company petitioner and they are employing people at a customer site, there is in February, about a year ago, the USCIS announced that they are going to have additional requirements on these third-party sites, calling upon them to provide contracts, work orders, itineraries, detailed letters attesting to the nature and the duration of the project, and a detailed request is often received asking the employing company to show how this meets with the standards of, quote, the employment relationship. So between elimination of deference of prior approvals and the third-party memo site, and the third-party memo policies and procedures, we're going to be seeing in these computer positions some serious challenges as we go forward. Let's move on to L1s. L1 is the other program that that many employers use for transfer of individuals in an intercompany relationship. So this is available to employees of a multinational company, and they are the individual must have been working for 1 year prior to the individual must have been working for 1 year for the foreign affiliate in a managerial, executive, or specialized knowledge capacity. That's what is required. Now, in August 2015, under the Obama administration, a policy memorandum was issued defining what is specialized knowledge. So if you have somebody who's managerial or executive, that's not so difficult. And it's still not so difficult if you can in fact establish that they are managerial or executive, and typically that's established by showing an organizational chart that shows them managing other professionals. And the more detail you provide in those managerial executive cases, in other words, who are they managing? What is their qualifications? The reports, the direct reports of this manager. I typically show a job description for the reports. I would show the degree of the reports. And if you show enough detail, you can do that. When it comes to specialized knowledge, however, it's become increasingly difficult to get a specialized knowledge worker because they've defined specialized knowledge as unique in the company, unique in the labor market, or somebody who has knowledge that is complex and cannot be easily imparted to another person. Let me just put this in terms of what lawyers can understand. I would say since this memo has come out, when this memo came out, I would say that the time it would take, the labor it would take to put together a petition for a specialized knowledge worker doubled. I would say in the Trump administration it has tripled. Whatever it took before 2015, you need 3 and 4 times the evidence, and you have to sit with your client and think through what can we provide to show that this is unique knowledge. And after you've done that, you have to be ready for a challenge saying you just didn't do it. So it's become very, very difficult to establish specialized knowledge and meet the test. There's also a new policy memorandum that the Trump administration issued recently that defines how you meet that 1 year. So traditionally, if the employee was in the United States working for the company in a different capacity or in a different category code, that meant that you could look back to the period of time. The 1 year within 3 years that's required is a look back from before they got here. But now they've announced that if they're here as a student, for example, then that 1 year period is broken, and you cannot rely on the 1 year before they got here as a student. So these little things are just making it more and more difficult for the process. Another thing that happens in these cases is that ultimately the process works by the USCIS has to approve the position and has to approve the process by saying that, yes, you meet the requirements for this position. Then the employee goes to the U.S. consulate abroad, and the consular office has to grant a visa. In many of these cases, particularly in H1B, we're seeing a higher level of something called administrative processing, where the government says, well, we don't know. The employee comes with an approval notice from the USCIS. That should generate a visa within 5 to 7 days, assuming that the security clearances don't come up with any hits, and assuming the interview goes well. But right now we're seeing a higher incidence of what they call administrative processing, which is sort of a mystical process by which they seek additional background or security checks or further review, and they don't really tell you what the problem is. Typically, these security checks, administrative processing would take 60 days to resolve, but we're seeing it now go to 90 or 120 days, and there's really nothing you can do about it. Even a congressional inquiry is not going to yield any results there. Okay, an increase in frequency of rejections at port of entries and consulates. Two things happening here. One is the administrative processing that I just mentioned. The other is the interview waiver program. At the consulate in 2012, the government announced that that many cases, renewal cases, can be waived, no interview for the candidate. But the Trump administration is focusing heavily on interviewing candidates, even in cases of renewals, and they're only permitting waivers for foreign diplomats, individuals who are applying for renewal within 12 months of the prior interview, and children under 14 and individuals over, I believe, is 79. The other thing we're seeing is that certain Canadians can apply directly at the port of entry. They can apply at the border or at the airport for an L1 petition, for an L1 approval. What we're seeing there is that historically, let me go back a minute. There are certain L1 employees who could apply directly at the consulate, and Canadians could apply directly at the port of entry. Or the rest of the world has to apply first with the USCIS. As I explained earlier, in a specialized knowledge case, the USCIS is very, very difficult. However, consular officers are less difficult if you can apply there directly. You have to have what's called a blanket approval to do that. They are less difficult, and they understand the need for migration of foreign talent to the United States, particularly if the individual is familiar with the processes, procedures, and special knowledge related to the company. That still works, but at the Canadian border, where it typically worked, where you saw a lower level of scrutiny, many of these CBP officers have now been trained by the USCIS and are applying the more difficult standards that the USCIS applies when processing an L1 specialized knowledge case, or any L1 case for that matter. And sometimes they'll say, yes, we approve it. Sometimes they'll deny it, and sometimes they say, we don't know. We'll send it to the USCIS and see what they have to say. We talked about the one-year employment abroad issue. Okay, so that's L1s. Permanent residence. As I mentioned earlier, this is a test of the labor market through the U.S. Department of Labor to establish that there's no U.S. worker to fill the position. The second step is proving to the USCIS that the employer and the employer are qualified, and the third is adjustment to a green card. Now, what I want to point out here is that the government has announced early on that this enhanced vetting will include an interview of cases that have previously the interview has been previously waived. In other words, under old procedures, if somebody went through these 3 steps that are defined in the prior slide, They've established to the dissatisfaction of the Department of Labor there's no U.S. worker. They've satisfied to the satisfaction of the U.S. Citizenship and Immigration Services that the employer is qualified and the employee is qualified, and now it's just a matter of establishing that there's an adjustment process and that this person does not have a criminal record, doesn't have a medical issue. There's no reason why he should be excluded from the United States. Those interviews were typically waived. Well, not anymore. Now, the problem with that is that there's two problems with that. One is there are not sufficient immigration officers to handle all of the cases, and that has caused a slowdown in processing. And number two is the immigration officers can now go back over all three processes and make a determination that there may be a problem. One has to question whether they have the training and capability of doing that. So what you're seeing is delays, and what you're seeing is the possibility of second-guessing the Department of Labor and the USCIS office that handled the second step and approved it. Okay, now let's go to permanent residence. Under our quota system, a family member can bring somebody from abroad. There is no quota, or there's an unlimited number of visas for spouses, children as defined, unmarried under 21, and parents of U.S. citizens. I suspect that if there is any kind of comprehensive immigration legislation passed by Congress, that parents of adult U.S. citizens category will either become quota or perhaps eliminated. But that's just a guess on politics, which is not really smart to do. There's a quota on these other categories, and some of them are backed up 12 and 15 years. Brothers and sisters of adult U.S. citizens are backed up significantly. Okay, now the proposed regulation I talked about earlier is that there's something called public charge, which means anybody coming to the United States has to be able to establish, based on the 5 factors that are here, they're in the statute, that that they will not become a public charge. They will be able to sustain themselves financially in the United States. This applies to employment-based cases. This applies to family cases. But most employment-based cases do not present this problem because the person has a job. But in a family-based case, okay, how is this person going to make a living in America? Okay, so at the moment, the way it's done is what I call an objective test. If somebody gives an affidavit of support and says, I promise you, United States government, that, and the details of the promise are really not relevant, the concept is relevant here. I promise you that this person will not need public support before they become a U.S. citizen, which is typically 5 years, sometimes 3. That passes the test. It's just an objective standard. Do the numbers shake out? The person giving that affidavit, do they make enough money? And once somebody in an office in Lee Summit, Missouri looks at this and says, okay, this passes the test, you get to an interview of this candidate, and you typically don't hear about this. I think that if this proposal passes, this proposed regulation passes, this is going to mandate that the USCIS interviewing officer at the end of this process will make a subjective determination. Who is this person giving the affidavit? How closely related are they? Will this person really have the government benefits within the next 3 to 5 years? Can the person really sustain themselves in the United States? I think to me, that's a game changer. When you put in the hands of a government officer a subjective determination, whereas opposed to now, it's an objective determination on the basis of statistics and financial information, I think it's going to change. Now, right now, the comment period has passed on this, and we're waiting to hear what the government does. I assume there were lots of comments that the USCIS is going to have to deal with, and we'll wait and see how this plays out. Processing delays. These are statistics published by the American Immigration Lawyers Association. The overall average case processing time has surged by 46% over the past 2 years and 91% since 2014. The USCIS processes 94% more of its cases more slowly than in 2018 than in 2014. If anybody's involved in this process, you know that everything takes longer. I mean, it just takes longer for just them to issue a receipt notice. It takes longer for a file to arrive at a local office. Everything in this process takes longer. I can't explain why that is, but everything is subject to processing delays, including what I spoke about earlier about administrative processing at the consulate. There's also an issue of, I think practitioners have also noticed that it used to be that you could somehow overcome a processing delay by congressional assistance, getting a senator or a congressman. Each senator or congressman has somebody in their office that is a liaison with USCIS and can deal with this. But recently, let's see, it wasn't recently, it was in December of 2017, the government said, the USCIS said, no, we will deal with you, but you're going to have a lot of documents that show that you are authorized to deal for this, your constituent, and it's become less helpful in terms of getting any kind of satisfaction through congressional intervention. You can still do it at the State Department level with a consulate abroad, but it's becoming much more difficult to get any assistance or any meaningful assistance from a congressional intervention with the U.S. Citizenship and Immigration Services. Okay, one final concept here. The countries affected by the travel ban are listed here. The travel ban requires there are exceptions or exemptions from the travel ban for diplomats, for dual nationals, permanent residents, and people who are in the United States. And the travel ban requires for anybody coming to the United States on a permanent basis or even a temporary basis subject to the ban, a waiver based on undue hardship, national interest, or and not a threat to national security. Travel ban is not something that comes up very much because of the narrow scope and the limited countries, but if it affects your client, it's going to affect them in a big way because they're going to need a waiver. Let me just say, let me just conclude by saying that maybe things will change. The future of immigration law, will Trump policies change due to low unemployment? They might. Trump, in his State of the Union address, at least in like a half a sentence, called for more permanent resident immigration, and there have been discussion. There have been they have floated the idea of a merit-based system, as opposed to what we have now, where it's a sort of what I would call again an objective test. Will this person's employment or permanent employment affect U.S. workers? But as opposed, sort of like the Canadian system, where you have a merit-based system. If you are really, really good, you can come here, and that's sort of the Trump approach to this. The highest-paid individuals, the highest qualified individuals should deserve to come to the United States. Okay, I think that's a basic overview of what's changed in the process since the Trump administration went into office about 2 years ago. Let me just say, if anybody has any questions, you can put in the chat. One question, though, that I do want to answer is, what about H1Bs for H1Bs for spouses of? I'm sorry. What about work authorizations for spouses who are whose spouses are in the labor certification in the permanent resident process? And under the Obama administration, I mean, during the Obama years, we saw that every little thing the government could do to help this process, they would do. In the Trump years, I think it's fair to say that everything they can do to stand in the way of the process, they're doing. But one of the things that the Obama administration did was said, let's say you're from India, and the quota system from India keeps you from getting a green card for, let's say, 8 years, because that's the way the system is structured. People from India have to wait that long. In the meantime, this person can continue to get his H-1B renewed. Now, the spouses were unable to work, so the Obama administration said, okay, we'll give you, if you've come to a certain stage in this process of the green card, permanent resident, then we will give you work authorization. The Trump administration announced that one of its goals is to eliminate this, and this has put the stakeholders who have work authorization under this program on edge. And the question is, do I expect that will be eliminated? And the answer is, I have no idea. It's possible that low unemployment has caused them to back off of this, but no one really knows what. This is a policy agenda. From time to time, the government, I think it's every year, I think they have to announce what their policy agenda is for the coming year. This elimination of employment for H1B spouses who are in the green card process was announced, I believe, last year, but nothing has happened about it. So the question is, will this be eliminated? The answer is, you have to wait and see, I suppose. There being no other questions, Crystal?
Yes, thank you. Yeah, thank you, Joel. That was wonderful. As always, it was a pleasure to have you on today. Before we sign off, I just wanted to remind everybody that in the next few days I will distribute a copy of this presentation, a recording of the webinar, as well as Joel's contact details. Please do not hesitate to reach out to him directly if you have any further questions. Also, please feel free to forward the recording on to others who may find it of interest. With that, thank you again for taking the time to join us today, and I hope everybody has a great day. Thank you, Joel. Bye.
Okay, thank you.
Bye. Bye-bye.